Welcome, everyone, to the Osher Lifelong Learning Institute at UC Berkeley. This is our Friday speaker series. You know that in this series, we talk about the leading edge in politics and current events, scientific breakthroughs, and advance our own understanding on the things that are happening in our world. I'm Susan Hoffman, Assistant Dean of Lifelong Learning and Ollie's Director. Today, we have joining us Jeff Ruch, and we're really happy that he can be here. He has been very busy, you can imagine. Jeff has been providing legal representation to government scientists, engineers, attorneys, rangers, and other professionals for more than 30 years. He's co-founded the Public Employees for Environmental Responsibility, which is called PEER, and he has served as its executive director for 23 years. We will give you that website so that you can also visit it, which is peer.org. Jeff has also served as a committee counsel in the California State Assembly for more than a decade and drafted California's State Whistleblower Protection Act, considered the strongest among state law. Jeff, as I said again, I know you've been very busy, exhaustingly busy, a lot to talk about, and I really appreciate that you're joining us today.
Well, thank you for having me. What I'm talking about today is entitled The Impunity of Government Disinformation. And what I'm going to do is three things. First, give a very brief overview of the legal terrain of government speech. Secondly, give a synopsis of the havoc that's been wreaked in the first 5 weeks of the Trump administration. And finally, make some suggestions for reform and new directions we can go. And I'd like to begin by quoting the late, great Daniel Patrick Moynihan, who famously said, everyone's entitled to their own opinion, but not their own set of facts. In government, that's not true. Government is entitled to their own set of facts in that they can suppress information, skew it, rewrite it to basically promote the talking points. It's often said that the truth will set you free, but in an official government context, it can get you fired. And we have lots of cases where that's the case. Perhaps the best place to start is the constitutional setting. So in the United States, there's something called free speech. And free speech rights used to extend to public employees. But in a 2006 case, the seminal Supreme Court decision, the court, in the case of Sabalas v. Garcetti, decided the opposite. This is a case where Sabalas was a deputy DA in Los Angeles, and he felt the LA Sheriff's Department was providing false information to support search warrants. And he started protesting and going to bar association meetings and others to sort of blow the whistle on this. His boss, the DA, Gil Garcetti, told him to shut up. Sabalas wouldn't do it. The case ended up in court. Sabalas prevailed at the district and Ninth Circuit level. It went to the U.S. Supreme Court. Unfortunately, Sandra Day O'Connor, at that point, left the court to care for her sick husband, and the case had to be re-argued. And the new justice was Samuel Alito. And this was his first swing vote, beginning 19 years of Alito being in the background of pretty much every constitutional reversal since. What the court held was that government employees at all levels have no, as in zero, First Amendment rights when they're speaking as government employees. And the court reasoned that was the case because the government owns their speech. So that remains the state of the law even today. However, the court said that government employees can regain their First Amendment rights if they step outside their role as a government employee and act completely as a citizen. And they revisited this question 8 years later in a case where an auditor in a southern school district had reported fraud by his superiors. It resulted in a criminal trial. He testified against his superiors and was fired for that stand. This case reached the Supreme Court with the opposite result, where the auditor lost at the district and the appellate court level. And when the court got to it, I think they finally realized the perverse implications of their earlier ruling. And so, as often happens, they developed a tiny little exception. And in this exception, they said, well, because he was testifying under oath in a criminal case, he was acting as a citizen and therefore not as a government employee, and he was protected by the First Amendment. That caveat, while it's important, really underlines just how bleak the state of the constitutional law is. So when employees speak in their own behalf, it's not necessarily that simple, because just as our First Amendment rights are not unlimited, the proverbial you can't shout fire in a crowded theater, government employees have an even stricter calculus in that their speech, the public importance of their speech is measured against the disruption it can cause to the agency. And that balancing test will determine whether or not they have First Amendment rights when they speak out. The further complication is that besides this calculus, there are additional conflict of interest rules and things like that, where government employees are constrained against taking public positions against their own agency. And to show you how extreme this is, the organization I represent is representing a National Labor Relations Board attorney who is facing sanctions for her activism on national park issues. The parks have nothing to do with the NLRB, but the interpretations of conflict of interest extend that far. On Tuesday, we're filing a lawsuit to argue that that position violates her constitutional rights. But that shows you what the state of the law is, and thus it's sort of very uneven. There are all these kind of constraints. So in the absence of really any meaningful constitutional protection, statutory safeguards take on a greater importance. And the biggest statutory provision in this area is the Whistleblower Protection Act. So by law, government employees at the federal level and pretty much at every state level are not supposed to be punished in connection with their disclosures. I'm going to quote from the federal law: the disclosures have to be evidence of a violation of law, rule, or regulation, gross waste mismanagement, or imminent danger to public health or safety. Absent that, there is no legal protection under the Whistleblower Protection Act. Policy dissent is not protected. The fact that something may seem unfair or inequitable is not protected unless it falls into one of these three narrow, very specific categories. It is not considered protected speech under the Whistleblower Protection Act. However, just because you have whistleblower status, it's not like this means that government employees have a suit of armor and they can walk around kind of invulnerable. What the whistleblower protection means is that you have an affirmative defense against an adverse personnel action. So rather than a suit of armor, it's more like an insurance policy if you get hit by a truck in an intersection. So it's a make-whole remedy in the sense that the law will reverse the termination or suspension or whatever negative action has happened. But it's beyond the jurisdiction of the law and the forum in which you're in front of for the court to address the underlying problem on which you blew the whistle, to correct the problem that caused the person to take the career risk in the first place. And so as a result, whistleblower protection has sort of a place, but in terms of correcting the record, it really doesn't provide much by way of protection. The additional problem we have, and I represent a lot of government scientists, is that government scientists often are kind of in a hot seat, and increasingly as things become more complicated and technical, scientific information is important in making decisions, and thus the amount of political pressure brought on scientists is greater today than has been ever before, and certainly is a sea change from where it was a generation ago. But generally speaking, scientists are not whistleblowers. They're disclosing problems with populations of fish or the mixture of gases in the climate or other kinds of things like that. And what they are often feeling pressure about is not because they're blowing the whistle. It's because the nature of their work is controversial or undermines the official talking points. And so we often see cases where scientists are very well regarded. And then when their information somehow complicates the official agenda of their agency, they suddenly find themselves marginalized. They go from golden boy to pariah through no real fault of their own, other than the implications of their work. And this is an area where there's almost no legal protection. So scientists who are in these situations or try to correct the official record or do things like that often find themselves in hot water with very kind of little recourse. So scientists in federal service, for example, a scientist who's forbidden from submitting his or her research for a peer-reviewed publication has no recourse at all. It's not even considered a personnel action. There's no way to challenge that. You can't take your agency to court to get your work published, and you risk punishment if you circumvent the official clearance process and submit it on your own. Similarly, you don't have any right to make presentations at professional societies or conferences or things like that. And you don't have any right to continue a particular line of research. And so often scientists who develop information that will upset a Monsanto Bayer kind of interest in, say, in the Department of Agriculture. We represented an entomologist whose work on pesticides upset that company, and they exercised influence to basically have his work curtailed. In those instances, there's no direct recourse in that. But the irony of this is that scientific careers are often extremely delicate. If you haven't published in your field for a period of years, it's a problem. You might as well be considered in a coma. But an agency can basically put you in that limbo without fear of any kind of challenge or reversal. One thing that's developed over time, largely because of abuses of prior administrations, have been things called scientific integrity policies. And they were first developed under Obama in reaction to the actions under George W. Bush, where they were doing things like taking documents and eliminating all references to climate or taking findings and completely reversing them. Those sort of extreme political interventions down to the field level of science actually framed the issue of there need to be some sort of constraint. So Obama, and shortly after his inauguration, directed all federal agencies to develop policies to prevent political interference with science. And the problem with those is that they rely upon agencies to police themselves, to exercise restraints on their own political appointees, and to basically do things that aren't in their own institutional self-interest. And so these policies, for the most part, have been a failure. So when Trump first came into office, they're almost never used. And the only time policy was invoked was under NOAA, in a fairly noted case that was called Sharpiegate, where then President Trump took a NOAA map of where a hurricane was supposed to go, and with his Sharpie pen indicated it was going someplace where it wasn't going. And then when his own National Weather Service contradicted him and said, no, the map was right, he put in orders to basically punish and silence those people. And the person that he put in charge of that, there was a finding against him, but it was no negative career consequence. And that same official, Neil Jacobs, is now the brand new head of NOAA in the second term. So all that sort of indicates that the protections for government scientists from political intervention are flimsy at best. Now we have the return of Trump, and he has sort of declared his desire to take his revenge on the deep state and to do other things that involve basically the promotion of alternative facts. So one of the things he's doing is he is trying to revive his plan to demolish civil service protection. So in the civil service, you have tenure, and the tenure consists of due process rights, which means there has to be you have the right to appeal, and the agency has the burden of proof to show the misconduct or other performance issue is valid, and that appeal rights can go up. So he's trying to eliminate civil service status for all employees in policy-making positions, which generally is between a quarter to a third of the top echelons of these agencies. And he's calling this new category, he's trying to create Schedule F, and those Schedule F employees will be terminated at will, meaning that they have no tenure rights, and like the thousands of probationary employees that were just summarily fired over the last couple of weeks, they would be fired. And the net result of that would obviously be a much more compliant bureaucracy, and anyone who dared to speak out or forward inconvenient facts would do so at his or her own peril. So Peer right now is the lead plaintiff in the lawsuit that was filed last week against the formation of Schedule F, and will likely be involved in that litigation for the next 2 years. And we'll see. The last time he tried to do this at the end of his first term, he ran out of time and it was reversed under Biden. Now he's beginning on day one, and so we'll be in the trenches fighting him since day one. The other thing he's doing is he's dismantling whistleblower defenses. So these scant defenses are now under direct attack. So one of the key people that enforces whistleblower rights is called the special counsel. It's not the special counsel you read about like Jack Smith, who does the prosecutions of the president. The Office of Special Counsel is supposedly the merit system police force. So they enforce laws like the Hatch Act that prevent politicking on the job, discrimination against veterans, as well as retaliation against whistleblowers. So Trump fired the Biden-appointed special counsel, who was a 5-year term and supposedly can only be removed for cause, without notice and without cause. That person has now been restored through a temporary restraining order, but in essence, his fate isn't known. Similarly, the special counsel acts as like a prosecutor, and the civil service court above it is called the Merit Systems Protection Board, or MSPB. And you'll read about this because it's sort of in the news now in connection with a lot of these issues. He also summarily removed the chair of the MSPB, and she has since been restored on a temporary restraining order. But the idea is that if there's no one around to enforce these protections, then they're absolutely meaningless. And to give you some indication of the direction this is heading, under Trump 1, he refused to make appointments to the MSPB, a 3-member presidentially appointed Senate-confirmed body. And they quickly lost their quorum. They were down to 1, and for most of his term, there were no MSPB members, which meant that the appeals couldn't be addressed. And so they would pile up in a giant backlog. By the end of his term, there were almost 4,000 cases that were pending decision. And so if there's nobody to make these decisions and exercise these rights, they become meaningless. And hence, in talking about the impunity of government disinformation, this shows you kind of the depths to which impunity can quickly reach. Another layer of protection are inspector generals. So inspector generals were post-Watergate reform authored by the late Senator John Glenn, the astronaut, taking an institution that has military roots. In the military, there are inspector generals that report to the command. And the idea was the inspector general would be sort of quality control, both an audit of finances, but also investigations of misconduct in government. And those institutions have grown up. There are now 36 of them, attached to each major federal agency, presidentially appointed, Senate confirmed, and by law can only be removed on notice from the president for a cause. So what's happened this time around is that Trump summarily removed 17 of the 36 inspector generals, including several he had appointed. And these are in agencies like EPA, Interior, Health and Human Services, et cetera, et cetera. So a large part of government, the supposed watchdogs have, in essence, been euthanized. And the problem is, one of the problems, besides the removal of these people, is that they're often a safe haven for whistleblowers to report information that is then validated. And often, if it's done well, it's done without implicating them or putting them on Front Street, having to risk their careers. So in the removal of these special counsels, we have a number of clients whose confidential information could be breached if they're replaced, as we assume they will be, by Trump uber loyalists, as he's almost all the appointments this time around seem to reflect. And further, we've had people that have reported problems, say, in the oil and gas industry that don't match that would be inconvenient to a Trump administration, where the inspector general is declining to open investigations into these topics. And even further, the concern is that these guardians will turn into plumbers unit, whose main job is to find leaks and to close them, that basically become, rather than sources of protection, sources of oppression. And we're now in kind of the opening weeks of that. These inspector generals, most of them have sued to get their jobs back, but whether they do or not, the bipartisan support for these institutions and trust in these institutions, I think, has been irrevocably lost as a result of this work. And so the lessons we're taking from all this is that in order for these checks to be effective against an aggressive executive, they have to be externally enforced. Having all of these things within the control of the executive branch makes them subject to compromise and undermining in a way that makes them kind of ultimately ineffective. And if they're ineffective, then there is no internal check on the quality, accuracy of information that the government distributes or uses. And in essence, they're free to continue to act in a realm of science fiction. There are a number of things that could be done kind of in the short term. What I was going to talk about just very briefly are kind of some kind of minor repairs that we could make, and then some structural changes that would make a difference. So one kind of minor repair, and most of these require statutory changes, and so they're probably not in the offing for at least the next 2 years. But the Freedom of Information Act, authored by the late Representative John Moss of California, is one of the most powerful transparency tools in government. Its effectiveness is limited because one of the exceptions for FOIA, as it's called, is deliberative information. And so tightening up that exception so that scientific information, for example, can never be considered deliberative and always must be revealed in response to a request would make a big difference. Similarly, requiring that all of the scientific information, even if it doesn't support the official position, and especially if it doesn't support the official position, be part of the administrative record in the case of a lawsuit, means that all of that dissent will eventually come out. And these lawsuits that ultimately kind of weigh whether or not the action is going to be allowed often come down to a question of whether the government's factual basis for their position is reasonable. And in these instances, and our clients are often the subject matter experts for the agency itself. And if their information is suppressed, then the government position looks good. If that information is part of the calculus, it undermines the government position. And what nonprofits like us have to prove when we try to invalidate government actions is that the agency action is arbitrary and capricious, is the term of law. And that's a very, very high standard. It's the highest standard in civil jurisprudence. In essence, you have to prove that the agency is acting irrationally. And the principal tool for doing that is by being able to utilize the unvarnished information from their own experts. And so doing that would make a fairly significant difference. And in addition, letting government scientists, making it clear that they can participate in professional societies and share their data and research findings without interruption as part of what is considered part of their duties would make a huge difference, because you would have a much higher level of transparency. And if the basic research is available for others to examine, it becomes harder for the government to reach conclusions that are contrary to the data that everybody all knows. In addition, with respect to science, a lot of what I do is try to create a new body of law, which I call the law of science. One part of it would be to create statutory protections for researchers and the research products that don't exist. So if they had the same legal status as whistleblowers, people who, for example, participate in the peer review process as authors or reviewers cannot be punished in connection with those activities, that would make a sea change and would give embattled scientists, we often call them combatologists, in that they're in combat and they're ologists, some legal foothold where currently they have almost none. Similarly, providing by law that government scientists can submit their research for peer review publication, and if the permission is not granted, that they have the ability to appeal rights such that there's an ability to enforce the proposition that research cannot be withheld from publication for non-technical reasons, i.e. political reasons. That would make a big difference as well, because these dissident scientists could get their information out, and that would make kind of a huge difference. The other thing is that even in instances where an agency has been found to engage in arbitrary and capricious information, the decision maker is never punished as a result of that. Typically, they're actually promoted because they're promoting the agency agenda. There's no connection between a finding by a federal court, a final finding, that some manager has made a decision that's contrary to law. There's no connection between that finding and that manager's personnel record. There's not even a notation. There's no kind of reprimand. So to the extent that upper management, rather than being stripped of civil service protection, had to answer for their own actions that have been adjudicated to be illegal, would make also a huge difference. Those are what I would consider minor repairs. In terms of major repairs, there's often discussion of checks and balances against executive power. And in this case, we have an executive who is kind of a megalomaniac in terms of trying to amass power. So, for example, one significant change would be to take the entire inspector general apparatus and move it from the executive branch to Congress. IGs don't exercise any executive function. They don't make decisions. They don't allocate money. They don't make grants. They audit and investigate, as the government accounting office does. Moving them wholesale to the legislative branch would insulate those positions from executive interference. Not only the positions, but also their work product would be free from approval of the executive, which now suddenly is in the last couple of weeks, and it would more tightly align their findings of waste and fraud and other things to the appropriation process, to make sure. Right now, inspector generals can write and issue the most scathing report on the planet, but they have no power to implement their findings, and agencies often ignore them. To the extent that they were part of Congress, Congress has many tools, particularly through the appropriation process, where they can enforce those recommendations and make sure that they're addressed. If that was done, that would also allow IGs, among other things, to operate scientific integrity policies, reviews. So one of the problems with the scientific integrity policies is that they are completely internal to the executive branch. And so, for example, when Biden came in his first week of office, just like Obama, he issued a new edict to agencies to restore public trust, to strengthen their scientific integrity policies. And for the most part, that made little difference at all in terms of the policies themselves. That executive order was repealed on Trump's very first day in office. And it made no difference at all in that, again, relying upon the executive branch to police itself is at best a fool's errand. If you had an independent entity like an inspector general that could do these reviews and also utilize experts on panels on questions of, for example, whether or not agency descriptions of research are accurate, and have that reviewed by independent people, sometimes even from other agencies, that would also be a sea change in that that sort of independent examination would mean that agencies would have to make things defensible and not proceed confident in the knowledge that they're not going to be contradicted by anybody that matters to them. And finally, one of the areas that is sort of an emerging concern, but if it goes any further, and looks like it's going to go further, will be a major problem, and that has to do with administrative law judges. Administrative law judges are these cadre of legally trained professionals who make decisions on internal agency appeals. Trump is now asserting because they are the executive branch, he can remove them without cause. And the concern is that the administrative law judge who decide everything from whistleblower disputes to contract disputes could be removed if they make decisions that are contrary to the agency. And so the idea that one side in a contest would control the referee is anathema to fairness. These administrative law judges and their function should by statute be moved to the judiciary, where they're a level below Article 3 courts and can provide a level of protection that otherwise doesn't exist and now is under great threat. So as we can see from all this, that things are headed in our view, in a very, very bad direction. And that unless there's some sort of reversal, future executives will take advantage of these same sort of prerogatives. And it's the prerogative to assert facts that are not true without fear of contradiction. And so until that happens, official information will continue to reign with unchecked impunity. So I'm happy to answer any questions.
Thank you very much, Jeff. There are, in fact, questions, and let's make our way through them. I mean, one of the questions, I think it was by our member Greenberg, back up here, Donald Greenberg, suggests, is there an advocacy body that is giving Congress the necessary information, about what's at stake and what to do? Is that you as well, or is there another entity that is helping, show what the possibilities are, what the stakes are?
Well, there used to be something called the Office of Technology Assessment, which was, I believe, also a post-Watergate measure that got eliminated under the Newt Gingrich speakership. So, and there's no comparable entity on scientific matters. And the GAO can fill that function, but it has a very, very wide jurisdiction. The reason I was pointing to moving the inspector generals over to the legislative branch is that the IGs, besides auditors and investigators, also have and can employ subject matter experts. So, for example, right now we have a group of clients that are EPA toxicologists who've asserted that official assessments on the risks posed by new chemicals have been altered under industry influence to eliminate evidence of unreasonable risk. The inspector general has been in a position to validate some of those concerns. The ultimate outcome of this case isn't known, but that sort of function otherwise doesn't exist.
Wow. And so in the answer to Donald's question, we don't know or we can't refer senators and congressional people to a particular agency or advocacy organization that will.
But we deal with them all the time, and I'm also a former longtime legicrat myself.
Okay.
The problem is that legislative bodies are not investigative of their nature. They're more jowl shaking once the investigation's been done. Their staffs are not experts. And I mean, we deal with them a lot. And the case right now, for example, of the Democrats in both houses and the minority, there's little they can do in that they don't have any gavels, they can't hold hearings, they can only kind of write letters. And the involvement of individual members of Congress or even committees in federal personnel decisions is somewhat awkward. There aren't really tools for that. And a lot of times, in our experience, the congressional involvement has been to remove some bureaucrat they don't like because that bureaucrat has done something that upsets a special interest that's major campaign contributors to them. So the involvement of Congress in kind of the nitty gritty of this is fraught with difficulty. Nonetheless, the Congress has the power of the purse, and the power of the purse was used to make sure that these individual problems were addressed. That would make a huge difference. But the quality of congressional work right now is really very, very low, almost kind of regardless of which party's in power. So, and for example, under Biden, you have Democratic majorities that don't want to do investigative work that will embarrass the Biden White House. And so that whole sort of partisan divide is another complication, which is why bipartisan supported institutions like inspector generals serve such an important function.
Mm, mm. Well, I think what was also partly behind, Don's query is Ollie members are eager to figure out where they can be involved, where they might have enough information that they can urge, their representatives or their senators. And so it sounds like a very complicated field, to exert any citizen response to it. So it's more
often, and so I don't want to make a self-serving, suggestion that they contribute to groups like ours, but in many instances, what we're doing is we're staffing the staff. So we're providing the information to the congressional offices. And in the case of our mission, we're public employees for environmental responsibility. Our job is to make sure that the message gets delivered without the messenger getting killed.
Right.
And so a lot of times, we get, people come to us with very unrealistic expectations, like that employees that come to us and say, well, I'm going to expose this and I'm going to go to Congress with sort of the idea that by providing that information, there's going to be a hearing, which will, of course, will be televised, and the problem will be addressed before the commercial break. And that almost never happens. And the incentive of members of Congress to go into the nitty gritty of these issues is also varied. It depends upon their campaign contributions and sort of things like that. And for example, the scandal I was mentioning involving the new chemical approvals, well, it started under Trump 1, continued under Biden. And so we could not get Democratic members to address this problem that was ongoing. And as a result, and just as a tiny aside here, the law that was being implemented there is the Lautenberg Amendments, 2016. The last major environmental statute enacted in the United States was the requirement that new chemicals be reviewed for risk before they go to the market, which is a fairly extraordinary thing. But it took a couple of decades to reach that. That provision has been exercised in a way that's been, in the view of our clients, in a careless fashion, as denoted by the fact that since 2016, not a single chemical has been blocked from the market. And that's because the industry still has that much influence through the top of the bureaucracy to make sure that inconvenient findings are altered, or in some cases, that's why we have the inspector general involved. In some cases, those findings disappeared. So documents were altered without track changes and sort of things like that on these kind of highly technical matters. And that's the battle that's going on inside the trenches of these agencies. And it's difficult for Congress in this higher level to intervene in a way that's meaningful unless the issue has been framed for them to act in a way that's amenable to their powers. I'm not being too
Yes. No, thank you
obtuse.
very much. No, I mean, it does in fact underscore the importance of peer. And thank you. And I'm going to put that website in our chat room. I want to go back to the top of the first point that was made by Bob Brewer, who I know was, I think if I remember correctly about Bob, he was a union negotiator. And he says, agree with problems created by not having a quorum on 3-member MSPB board, but it may be offset by 2 factors. First, appellants who receive an unfavorable ruling from an MSPB judge can bypass the board and appeal directly to the federal circuit. Second, if agency appeals an unfavorable AJ decision, the judge may grant interim relief. Any comment from you?
Yeah, the first point is absolutely correct, but the second point subsumes the first point, which is agencies always appeal, which means you don't have a final verdict. Without a final verdict, your ability to appeal is dependent upon judicial discretion, which is rarely granted. Nonetheless, even if that avenue is open, it's a hell of a way to run a railroad in the sense that the ordinary kind of administration of law doesn't work and would require upon grants of extraordinary relief. In the meantime, that whole process takes years. And so, for example, if you've been fired, then you are doing this multi-year battle, legal battle, without an income. Or so it's sort of so yes and no. It's a thin reed on which to hang your career.
Got it. Ollie member named iPad asked the question, is there a difference between free speech and intentionally spreading lies with no facts or no fact-based?
Well, so free speech, it depends upon the content or the context, in the sense of I'm using free speech in the context of constitutionally protected free speech, as in First Amendment rights, and there's no and so then the other kind of issue is whether or not you can be punished as a result. So you can be punished for example, falsifying research results and sort of things like that. But as to whether something's a truth or a lie, my larger point is right now there's no real judge, which is the executive controls everything. And so you can have an unmitigated reign of alternate facts without exception. And that's the concern.
Okay, moving on to the next question from Amy. In the case of scientists who discover findings contrary to their agency's position, how do they get around the issue of who owns those findings? Presumably they were discovered in the course of their employment. How can the facts become public?
And that is sort of the essence of the problem, is the Supreme Court has ruled that the government owns your speech, and as a practical matter, they own the research results, and this is all done on government time with government, and so that sort of cuts 2 ways, in the sense that the individual scientist does not have a proprietary ownership in that information, even though he or she developed it. But on the other hand, it was developed with public resources, and there's a public interest in having that information shared. And it's that second kind of basket, if you will, where there are avenues where information could be shared, because if it's going to be used, for example, there are policies, but again, these policies can be waived, that information relied upon for major decisions be peer reviewed. That often requires it's shared with outside people through the ordinary peer review process. And for most scientists, getting that information peer reviewed and published is their job. They're satisfied by that, and often they get professional recognition because of the advances their research means in their field. And when it's being interrupted because of kind of political considerations, they have the point of all this was they have very little recourse.
And does that also, that restriction apply to university-based researchers whose research is funded in part with federal dollars?
Boy, it can. Though the university is a different setting, we've represented a number of university researchers who have run afoul of political influence, but usually those restrictions are exercised through, for example, the state legislature. So, for example, we get a case where the Washington State Legislature threatened to withhold funding for a medical school at Washington State University because of a professor's finding about wolf behavior. And that was prompted by the agricultural industry. So so the university people are in a different setting. Nonetheless, they are public employees. There is an overlap in the same kind of concerns. But certainly with respect to federal funding, I believe that universities are now finding new restrictions on federal funding, for example, on the gender issues, climate issues, and things like that. And as to what that means, that's going to get slugged out almost contract by contract, project by project.
Mm-hmm. Very good. Oh boy. Okay. And then Rick is asking the question, are you aware of any current congressional leaders who are supporting putting the oversight in Congress around these issues? Have they offered any legislation in the hopes of a future Democratic majority that might pass it?
No, and also I haven't heard. I developed these recommendations for this talk. We hadn't been advocating them because there wasn't that much interest in them during the Biden administration, and we were only 5 weeks into the Trump administration, and so much has happened since then. I often joke that Pierre functions as a giant shelter for battered staff. That's what we've been doing for the last 5 weeks. So we have almost 200 clients that have fired probationary employees, environmental justice people, kind of things like that. And the appetite and also the possibility of meaningful reform would, I think, require a change in control of Congress and or perhaps the White House. As they say, elections have consequences, and right now we're still dealing very much with the consequences of the last
one. It does sound overwhelming. And let me ask then the last question from Mike. How long will it take for existing federal court through what he imagines is the Supreme Court?
I didn't really quite hear that.
How long will it take for existing federal court injunctions to be fully litigated before the Supreme Court? Or if it goes that far to the Supreme Court?
I'm not sure that there's just a pat answer to all that, but let me start with a couple of the concrete examples. So the special counsel removal and the IG removal and all those sort of things. Right now, they've won temporary restraining orders that restore these people to their positions in some cases, pending a hearing on the merits. So the hearing on the merits, for the most part, those are scheduled in March and April. Those hearing on the merits will then result in some decision. And at that point, when you're dealing with federal courts, there's no time clock in that it's not like these things are deemed approved unless they decide so much time. And then whatever decision is made there will, particularly if it's, I think any decision made there will be appealed by either side. And eventually this is all going to go back to the Supreme Court. So for example, the Supreme Court I think it was this week or the end of last week, declined to intervene to vacate the temporary restraining order restoring the special counsel. And so ultimately this is going to come down to the Supreme Court deciding whether or not, for example, the White House can, in essence, ignore statutes that say appointees like the special counsel or inspector generals can only be removed for cause. And even if they uphold that, then the concern is that Trump would then turn around and fire them and assert a cause that is unsupported or utterly false. At that point, then can you challenge that, or is the presidential finding unchallengeable? That's another round of litigation, how far that will go. But the notion is that the White House would basically run a game in which they control all the referees is the fundamental problem that, in my view, needs to be addressed. And it hasn't been as acute until very, very recently.
Mm.
So a lot of these people, I mean, a lot of the IGs were appointed by Trump. He didn't try and remove his own special. Anyway, what's gone on now is almost like the next generation of executive abuse. And that next generation, in my mind, calls for rethinking the balance, the checks and balances.
Mhm. Okay, well then, our next question from Andrew returns to that topic that you titled Decapitating of Civil Service, the elimination of civil service. And you brought up that Trump's efforts are being called Schedule F.
Schedule F.
Moving civil service positions. Can you tell us what the timeline is? Has it been implemented? Are there suits against it? Tell us a bit more about what's happening there.
So they have proposed to develop the first regulations. Last week, the first suit was filed against it. Peer is the lead plaintiff in that suit. And where it goes from here is unclear. We'll then go into it's in front of a U.S. district court. That decision has no particular timeline, but we would expect something within this calendar year. Then there will be appeals, et cetera, et cetera. So we're spending a lot of our time sort of reformulating ourselves to be basically kind of a litigation SWAT team. And we're doing so not just by ourselves, but in partnerships with unions and other nonprofits, so that we're not duplicating efforts.
Thank you. All right. And Kim.
And I was going to mention, we've had experience with those kind of systems in other states. So we do a lot of work in state levels. So, for example, in Florida, they instituted such a system under then Governor Jeb Bush, which not only quieted dissent within their department, the department we were dealing with the most was the Department of Environmental Protection, but it gave rise to a particularly insidious problem, which was specialists who raised problems were often then promoted so they could be fired.
Okay.
And that's a mind bender.
Yeah, right. Well, there are quite a few. Do liberals have any hope among Democratic politicians based on your experience? Who do you see who might rise to the occasion to face Trump with these in this area?
Well, and I'm a former Democratic staffer, and I don't think the problem so much is in the Democratic Party. Again, and I guess I was telling you about this earlier. I view these things as kind of swinging pendulums, and the greater abuse now is going to give rise to kind of greater reform. And so Watergate, and while that was 50 years ago, that was considered an executive abuse that required or merited or warranted a series of legislative checks, one of which was the Inspector General system and things like that. We're having another sort of Watergate kind of experience. And from that, out of that, assuming that there's the same sort of reaction we had then, there will be a new generation of reforms, and that will hopefully address some of the issues that I'm talking about, because the overall kind of question is kind of never again, how do we prevent this from happening? And Biden confronted that early, but he did so in a way that was so lame that it didn't make any difference. It was a rhetorical commitment, but no kind of actual commitment. So, for example, Biden could have done things like established rights of publication government-wide that would have been more difficult to repeal, or address some of the transparency issues. That could have been done administratively in a way, while Trump could reverse them, they would be difficult to reverse and would be much more favorable terrain to fight on than we have right now. But the other thing to note is that we are really only 5 weeks into this. And you know, um, the the capacity for the current administration for self-imposed harm is great.
You know, Jeff, in your experience, both with the California's legislature and with Congress, is there any chance? I like your hopeful message. Greater abuse leads to greater reform. How quickly, is there any chance that we could operate as quickly as 5 weeks to counterman this?
I mean, right now the hope is the court. So the Congress is in Republican control, and that may change in 2 years, and that would be another change in dynamic. And so, I mean, to the extent it's analogous, during George W. Bush's administration, the House was retaken by the Democrats in 2006, the middle of his second term. That resulted in a series of hearings that exposed scientific misconduct. So one of my favorite was an official who told a field biologist to a report that recommended the listing of a particular species to leave the 300-page report intact, but change the conclusion. And she did this by text from pos to neg. And so she just changed the whole. Anyway, those kind of things sort of came out in hearings in ways that caused this person to resign, and sort of the last 2 years of the Bush administration were muted and led to the Obama attempt at scientific integrity policies. But had Obama, instead of trying to do this internally, proposed that Congress do it, then history might be changed, because there would be statutory protections that now don't exist.
Okay. Well, Jeff, last week, climate scientist Dan Kamen talked with us and was talking about the issues around climate justice. And he is moving from Berkeley to Johns Hopkins to work with the Bloomberg Center for Sustainability. I'm hoping, that if ever you should need anything in this area, that Dan would be available. He's kind of an international figure at this point. We had him last week, and he was calling in from Berlin. But it does seem like we've got to marshal our forces, and all of us on a timeline, that is making big changes as quickly as possible, and not just simply in reaction.
Well, and I just want to do one tiny bit of whining, and that was the lack of action under Biden. So one of the areas we litigated under was the use of administrative leave. And administrative leave is a thing where they take an employee and they say, okay, you're assigned a home, and you may not do any work, you're still going to be paid, but you're on administrative leave. And administrative leave is not considered a personnel action, so you can't appeal it through the special counsel or MSPB. It's unlimited in how long someone can be left on administrative leave, or how many people you can put on. So we agitated this and finally got Congress, and we had a number of cases, because representing whistleblowers, they tended to be the ones singled out to be put kind of on the shelf. And bureaucracies tend to avoid making decisions that are difficult. So somebody left on administrative leave. So we had cases where people were left months. One was 5 years on administrative leave.
Wow.
With no kind of recourse. So Congress finally acted in 2016 to pass the Administrative and Investigative Leave Act, which required the administration implement it through regulations. So Trump didn't implement it. So when Biden comes in, we went to the Office of Personnel Management and said, for God's sake, do the regulations that implement it. So one of the key reforms was you couldn't put any person on administrative leave for longer than 10 days during a calendar year. Fairly basic kind of thing. We had to sue the Biden administration in early 2023 to get them to implement it. We don't know why they wouldn't. They finally adopted regulations in December of 2024 after the election, and those regulations become effective in September. So that kind of stuff that to us just drove us crazy, because our concern was administrative leave could be abused. And in this case, Trump would say everybody who's doing diversity, equity, and inclusion work is suddenly on administrative leave. You all go home. So you have about 2,000 people that have just been consigned to limbo without recourse because the Biden administration didn't do its job. The same is true with the environmental justice people that are almost all in EPA. So in representing those people, we're trying to figure out ways to basically get this sort of thing implemented, but also the concern for all of these groups is it's almost like they've been marked with a political mark of Cain, which is if you've worked on DE&I stuff, you're unemployable. We want you to quit and go away. And most all of these people are analysts, engineers, they have other specialties. Like, why couldn't they be employed in all the different vacancies you have? And the answer, which is not the answer that's said aloud, but the unspoken answer is because they have cooties. Because they worked in this area, we're not going to re-employ them. So we're going to be spending the next few months kind of litigating that kind of obscure sort of restriction. But to me, it just indicates kind of how unsophisticated oversight has become.
Right. Well, Jeff, thank you. Thank you for today. Thank you for the work that you have done for decades now, through many administrations. And hopefully you'll see more people visiting the website and using Peer as a resource. I will tell my colleagues who are concerned about DEI issues about peer.org as well. And again, thank you. Everybody have a wonderful weekend as best you can. And
I didn't mean to be Mr. Bummer. Thank you for having me, though.
no. Yeah, well, we understand. Thanks, Jeff.
All right. Bye-bye.